Section 107-14 of the Illinois Code of Criminal Procedure states that, quote, "A peace officer may stop any person in a public place for a reasonable period of time when the officer reasonably infers from the circumstances that the person is committing, is about to commit, or has committed an offense, and may demand the name and address of the person and an explanation of his actions." This statute mirrors the reasonable suspicion doctrine established in the infamous Supreme Court case of Terry versus Ohio, requiring an officer to point to specific facts that led them to believe that criminal activity is taking place in order to detain an individual. As the Supreme Court explained in the 1979 case of Brown versus Texas, quote, "We have recognized that in some circumstances, an officer may detain a suspect briefly for questioning, although he does not have so-called probable cause to believe that the suspect is involved in criminal activity. However, we have required the officers to have a reasonable suspicion based on objective facts that the individual is involved in criminal activity." While applying this standard, the court determined that it was a violation of the Fourth Amendment for officers to detain an individual and require him to identify himself simply based on the fact that he, quote-unquote, looked suspicious, and the officers had never seen that subject in the area before, because the officers lacked any reasonable suspicion to believe that he was engaged or had engaged in criminal conduct. Accordingly, although the doctrine of reasonable suspicion is an extremely low bar for members of law enforcement to meet, purely legal and innocent activity generally cannot be used to justify reasonable suspicion on its own, and some objectively criminal element must be present in order to establish reasonable suspicion.